I don't believe you. And let me just tell you why I don't believe you. If a program has been ordered and you're sick and they tell you, oh, we need to see you today, what you tell them is like, I'm sorry, I think I have COVID. I can't see you today. I'm very interested in your program and I know the judge has ordered and I want to be in it. But instead, you didn't do that. So don't come to me telling me stories that make absolutely no sense. Nobody does that in the real world. So when I order something, you need to follow through. If you don't want to follow through, let us know. We'll move on to the next person. I do remember the names and faces of everybody that I sent to prison. But if you wish to go to prison and be done with this, I will send you. And guess what? I'll move on to the next person and see if they would like to be in programs that are presented.
Today, we are in Judge Boyd's courtroom observing a defendant who appears intent on challenging nearly every directive issued from the bench. Although the judge communicates his orders with clarity and specificity, she responds as though they are mere formalities, dismissing them with what seems to be instinctive indifference. This does not present as a principled legal disagreement or calculated advocacy. Rather, it resembles resistance for the sake of resistance. It is worth emphasizing that a judge has the immediate authority to impose contempt sanctions, meaning that even overt displays of defiance can carry swift and serious consequences. The tone of the proceeding begins to feel less like a structured legal hearing, and more like a rapid demonstration of how easily one can jeopardize their own case. Her conduct raises a broader question. Is this behavior rooted in frustration with the court, or does it reflect a deeper disregard for her own legal interests? Ultimately, one must ask whether it is ever prudent to risk incarceration simply to challenge the authority of the individual presiding over the courtroom. Let us examine how the situation develops. 1.
All right, court is calling 2024 CR 1983, State of Texas versus Ashley Draper Ward. Could I have parties announced for the record for the state?
Oh, sorry.
For the defense?
Christopher Simpkins.
And are you Miss Ashley Draper Ward?
Yes, ma'am.
Right. So you entered a plea of guilty. The judge found there was sufficient evidence to find you guilty. According to the plea bargain agreement, the state is recommending community supervision. Have both parties had a chance to review the PSI report, state?
No, Your Honor, but we're okay with proceeding anyway because we are recommending meetings.
All right, defense. All right, any objections to the PSI report?
None, Your Honor.
No, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, I believe she's motivated. She'll be successful, and she understands that she faces severe repercussions if she does not live up to her obligations. But that's what she follows the bargain agreement.
All right, Ms. Ward, do you have any family support?
Yes, ma'am.
All right, who's your support system?
My grandmother's.
All right. And do you have any children?
3,
Okay, what are their ages?
5, 6, and 8.
And who are they with?
My mother-in-law.
And have you had any CPS cases in regards to them?
No.
When's the last time you had contact with them?
Before I was incarcerated.
So how did it come to be that your mother-in-law had custody of them?
My first incarceration, she took custody while I was incarcerated.
Okay. All right, this is what the court is going to do. Court is going to sentence you to a $500 fine that's going to be probated.
Okay.
4 years deferred adjudication in states you may continue to confer. There's going to be 100 hours of community service restitution. I'm going to order you to complete parenting classes.
Yes, ma'am.
There's to be no unsupervised contact with minors.
Yes, ma'am.
There's to be regular reporting by Zoom or in person. I'm sorry, Miss Ethel, if you could move so probation can, yeah. There's to be regular reporting by Zoom or in person. There's going to be anger management.
Yes, ma'am.
She's going to remain in custody for her Tacoma exam, and they say that's scheduled at August 22nd.
Yes.
And we'll follow those, what their recommendations are. If for some reason she's not accepted, then we're going to do a referral to Center for Healthcare Services. You're going to need to sign a release for any type of medical treatment that you're receiving. You understand?
Yes, ma'am.
There's to be regular UAs, proof of employment, or SSI, within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits, one time per month until she receives her case manager. And that's the case manager for mental health. Sorry, just let me check one thing. And also, let's do a referral to felony drug court.
Judge Boyd sets forth straightforward conditions: consistent reporting, completion of anger management programming, and full compliance with supervisory requirements. These directives are neither excessive nor punitive in nature. They are structured mechanisms designed to measure accountability and promote rehabilitation. Nevertheless, her demeanor conveys uncertainty, if not outright reluctance, regarding her willingness to meet these expectations. The impression given is akin to someone verbally agreeing to responsibilities, while internally resisting the commitment they require. Though the obligations themselves may seem routine, they serve an essential legal function. They evaluate whether a defendant can demonstrate sustained, law-abiding behavior over time. Courts carefully track compliance, and each missed session, each failure to report, and every deviation is formally recorded. When violations occur, the resulting penalties frequently surpass the severity of the original disposition. That trajectory appears increasingly plausible in this instance. Anger management requirements are not symbolic gestures. They operate as measurable benchmarks of engagement and reform. Judges are particularly attentive to any perception that court-ordered opportunities are being treated casually or without genuine effort. Perhaps most concerning is the possibility that she does not recognize how her demeanor is being interpreted. This does not resemble a strategic effort to navigate the system. Rather, it appears to provide additional documentation of potential noncompliance. At this juncture, the issue may no longer be whether difficulties will arise in fulfilling these obligations, but when they will occur, and what justification might follow.
And we can also do a referral to mental health court and let mental health court know that if she is accepted to mental health court, the court will entertain a motion for new trial, because they'll only accept her if she does not have a open probation case. And the reason why I'm doing that, I think that they will be able to address any issues you have weekly more than this court is able to do. Do you understand?
Yes, ma'am.
All right. State, are you going to have any objections if mental health court were to accept her to for a motion for new trial?
Not at this time.
All right. Probation, is there anything else she needs?
No, Judge.
All right. Is there anything else you need in order to be successful?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I'll move that.
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Don't use your mental health issues as an excuse. Do you understand? I understand mental health, but you were involved in a dangerous situation that could have ended very badly for you. You understand?
Yes, ma'am.
All right. And what's up with all the names? Whose names?
My kids.
Hmm?
My kids.
All right. I always tell people, if you're going to put a name on your body, children, mom is usually a safe bet, not your significant other, okay?
Mhm.
All right, if you need anything, you feel like they're not addressing it, you can always come back to court, okay?
So,
All right, what's in your ear?
earplugs,
I'm sorry, oh, earplugs? Well, how are you able to hear with earplugs?
they're not very good.
Okay. How does she get earplugs at the jail, or do they make those? Okay, so here's the thing. I know at the jail people make a lot of things, but all of that is considered contraband and it'll get you in trouble at the jail. Okay.
Okay.
All right. Good luck to you. All right. You have a choice today. Here's your choice. And these are the only two choices you have. You're either going to felony drug court or the state will file a motion to revoke. I'll hear the motion to revoke. And if I find that the allegations in the motion are true, you're looking at 2 years in the state jail facility. Those are your two choices.
I'm going to show you.
All right. Why do we need for you to come here to follow the rules that the court has set in place for you? Why do we need to have this conversation when all you had to do was sign?
Yes, ma'am. I'm sorry. I didn't intentionally miss. I don't know if I had to pull it or what, but I was really sick, throwing up, and
No, that's not what they tell me happened. They tell me you refused. It wasn't.
That's why I refused. I was really sick, and I had been sick call, but they wouldn't call me out.
No, I don't believe you. And let me just tell you why I don't believe you. If a program has been ordered and you're sick and they tell you, oh, we need to see you today, what you tell them is like, I'm sorry, I think I have COVID. I can't see you today. I'm very interested in your program and I know the judge has ordered and I want to be in it. But instead, you didn't do that. So don't come to me telling me stories that make absolutely no sense. Nobody does that in the real world. So when I order something, you need to follow through. If you don't want to follow through, let us know. We'll move on to the next person. I do remember the names and faces of everybody that I sent to prison. But if you wish to go to prison and be done with this, I will send you. And guess what? I'll move on to the next person and see if they would like to be in programs that are presented for them. All right. Ms. Abrams, is felony drug court willing to accept her? All right, you're going to felony drug court.
Through references to mental health challenges. Courts do, in fact, acknowledge and carefully consider mental health factors. However, such considerations must be accompanied by consistent and responsible conduct. Verbal assertions alone carry limited persuasive value when observable behavior suggests instability or a disregard for courtroom authority. Judge Boyd offers candid guidance, urging her to focus on meaningful, enduring commitments rather than temporary or impulsive decisions. His remarks extend beyond the immediate case, emphasizing the importance of long-term responsibility and thoughtful prioritization. Yet the substance of that advice appears to have limited impact. Compounding matters is her decision to wear earbuds during the proceeding, an action that, regardless of intent, conflicts with established courtroom decorum. Courtrooms function under clearly defined standards of respect and attentiveness, and even minor gestures may be perceived as inattentive or dismissive. From a judicial standpoint, maintaining order and authority is fundamental, and conduct that undermines that structure may invite contempt considerations. What may not be fully appreciated is that such behavior affects more than her personal standing. It consumes court time and resources that others rely upon for legitimate relief. Rather than strengthening her position, her actions risk eroding her credibility and reframing a serious legal matter as a display of disregard.
All right, the court is going to call 2024 CR 1983, State versus Ashley Yvonne Draper Ward. Could I have parties announce?
Andrew Harrison for the state.
Melissa Christian for the defendant.
All right, and Naomi, could you hand me a file stamp for a motion to revoke? And are you Ashley Yvonne Draper Ward? You're going to need to speak up.
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ashley Yvonne Draper Ward who was placed on deferred adjudication in 2024 CR 1983 for the offense of attempting to take a weapon from an officer on June 27, 2024 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
On or about the 23rd day of December 2024 in Bear County, Texas, the defendant Ashley Duvon raped the board committed the offense of tampering with electronic monitor in violation of condition.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations.
Any objection?
No, Judge.
All right, did you understand by pleading true to violation condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is not, Judge.
State, what are you requesting?
Adjudicate guilt, assess punishment at 2 years of confinement in the state jail facility.
All right, and defense, what are you requesting?
Judge, she has 415 days credit. So we are asking the court to give her credit for time served.
All right. So you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Ashley Yvonne Draper Ward.
All right, what have you done while you've been on probation? Well, let me do this. Did you complete parenting classes?
I did several of them.
But did you complete it?
No, ma'am.
Why not? Deputy Laura,
The program.
excuse me, you're not dressed appropriately for court. Yes.
Because I left the program, ma'am.
All right, why did you leave the program?
I acted on impulse.
All right, that doesn't explain why you left the program. What was the impulse you were acting on?
Just overwhelmed. There was a lot going on up there, and I just got fearful when I left.
All right, did you complete anger management?
Yes, Your Honor.
All right. And with regards to the referral for Center for Health Care Services, had you been in contact with them?
Yes, Your Honor.
And were you employed?
Yes, Your Honor.
Doing what?
Worked at Little Caesars, and then I was a home health care provider.
Oh, see, I don't even know why that's being allowed, because I don't allow people to be home health care providers. And I specifically said no employment as a home health care provider. You're overwhelmed by life, and yet you're somebody's home health care provider. But I don't allow people who have felony cases to be home health care providers.
Yes, Your
So
Honor.
that's number 1. Probation, what are you recommending?
Judge, probation's recommendation is to amend for safety, followed by aftercare.
All right. You have a choice. You can go to safety, or I can revoke you. And if I revoke you, I'm sentencing you to the 2 years. Either way, time is going to pass in your life. It can either pass with you in safety, and you're going to get extended on this probation, by the way. If you go to safety, I'm going to extend you for a year. So if you want to just do your time, you can do your time. You can go to the state jail facility. I'm going to sentence you to 2 years, or I will send you to safety.
You'll get credit. The judge will give you credit for time served. State jail does their own calculations.
All right, this is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $500 fine, time and money for unconcerned, and I'll recommend the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
You have a limited right to appeal, and that right to appeal is that it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. So you're going to be sentenced to the 2 years in the state jail facility. You are entitled to whatever time that you've previously served. And I'm going to recommend the therapeutic community. The therapeutic community is to help you hopefully get your life in order so the criminal system will not see you again. Do you understand?
Judge Boyd ultimately presents a direct and unequivocal decision: participation in felony drug court or a 2-year term in state custody. There are no alternative arrangements, hidden exceptions, or discretionary loopholes beyond these two options. Felony drug court programs are structured to provide rigorous rehabilitation and an opportunity to avoid incarceration, contingent upon strict compliance and personal accountability. Instead of embracing that opportunity, she offers explanations, such as illness or reluctance to sign required documentation, that appear less strategic and more self-defeating. It is notable that she seems indifferent toward an option that many defendants actively seek as a pathway to avoid prison. Declining entry into a rehabilitative program carries broader implications beyond personal preference. It narrows judicial discretion and often leaves incarceration as the remaining course of action. These courts were established to reduce recidivism and ease the strain on correctional systems while promoting recovery and structured reform. When such an avenue is rejected, the court's options become limited. This case prompts a broader reflection on why some individuals resist structured opportunities designed to facilitate success. The underlying reasons may differ from one person to another, but the legal consequences tend to follow a consistent and predictable path. Thank you for your time, and I welcome your perspective on the matter.